Because federal law protects job applicants against discrimination on the basis of race, religion, and sex, most employers don't ask about those subjects on job applications. Some state laws go further and prohibit employer inquiries on other topics, like criminal history. In Starbucks versus Superior Court, coffee giant Starbucks faced a class action for including a prohibited inquiry on its job application. Starbucks used the same employment application for its store employees throughout the country. The first page of the two-page form asked whether the applicant had been convicted of a crime in the previous 7 years. The second page had a paragraph containing several disclaimers applicable nationally, as well as specifically to Massachusetts, Maryland, and California. The California disclaimer stated that California applicants need not disclose convictions for marijuana possession that were more than 2 years old. The disclaimer paragraph was nearly 350 words long and placed above the application's signature line. Eric Lords unsuccessfully applied for a job at Starbucks. Lords had never been convicted of marijuana possession. He read the entire application, including the disclaimer paragraph, and understood that he didn't have to report a marijuana conviction that was more than 2 years old. Lords truthfully responded no to the question about convictions. Lords filed a class action against Starbucks, alleging that the job application violated a California statute prohibiting employers from asking about marijuana convictions more than 2 years old. Lords sought to represent a class of roughly 135,000 Starbucks job applicants throughout California, requesting the greater of actual damages or $200 for himself and each class member. The trial court certified the class and denied Starbucks' motion for summary judgment, ruling that the application violated California law and that a factual dispute existed about whether the disclaimer was adequate. Starbucks filed a petition for a writ of mandate with the California Court of Appeal, asserting that, because of the class size, it faced liability of at least $26 million. Therefore, the litigation posed such a great financial risk that the company might be forced to settle rather than risk an adverse judgment at trial. The appellate court took up the case.